THCA in Virginia enforcement looks simple on paper. The statute says one thing, lab reports say another, and most people assume that means the outcome is predictable. But, this is where enforcement changes everything. Because in actual Virginia possession cases, THCA isn't evaluated the way most people think it is. And the consequence of that misunderstanding doesn't show up on a label, it shows up later, during investigation, charging, or court review. We'll come back to that, because earlier assumptions fall apart once enforcement enters the picture. Here's the counterintuitive legal fact or misconception. Here's the counterintuitive part. Many people believe that if a product is sold openly, tested by a lab, and labeled as compliant, enforcement has to accept that classification. It feels logical. It is logical from a consumer standpoint. But Virginia law doesn't actually require law enforcement, or prosecutors, to accept a retail classification when evaluating suspected cannabis. And that gap between classification and enforcement is where THCA cases live. Let's challenge a belief we all likely hold. A lot of viewers come into this topic believing that enforcement starts with chemistry. That officers test first, analyze later, and decide based on numbers alone. Well, that belief doesn't hold up in practice. In Virginia, enforcement usually begins with behavior, appearance, context, and discretion. Chemistry comes later, and sometimes not at all. And once enforcement moves forward, the legal posture changes fast. Now, let me slow this down and explain what we're doing here. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. This video is not about how to buy, sell, use, or consume anything. It's not promotional, and it's not lifestyle content. What we are doing, more accurately, is examining how THCA in Virginia enforcement actually works once law enforcement, prosecutors, and courts become involved. We'll look at what the statutes say, how enforcement decisions are made, and why the legal outcome often turns on interpretation rather than chemistry alone. And we're going to close the loop on the uncertainty raised in the first two videos in this series. Listen. Everything you hear today is educational, legal, and compliance-focused. No advice, no encouragement, just explanation. Because understanding enforcement is about risk awareness, not participation. Here's the context. So, why does this issue exist at all? Virginia's cannabis framework developed in pieces. Decriminalization, hemp legalization, medical cannabis regulation, each arrived through separate statutes, written at different times, with different goals. THCA products entered the market through the hemp pathway, relying on Delta-9 thresholds rather than intoxicating potential. But enforcement statutes, particularly those governing possession, impairment, and unlawful distribution, were never rewritten to clearly account for high THCA flower. That's why confusion is common. The law evolved, but enforcement standards stayed rooted in older cannabis definitions. And this is where interpretation begins to matter more than intent. Here's the legal explanation. Under Virginia law, marijuana is still defined as cannabis containing a certain level of Delta-9 THC, excluding hemp as defined federally and adopted by the Commonwealth. THCA, chemically speaking, is non-intoxicating until heated. On paper, that matters. But enforcement statutes don't require officers to determine potential conversion at the roadside or during an investigation. They evaluate suspected marijuana based on appearance, odor, packaging, statements, and context. Let me rephrase that, because this part matters. The law distinguishes between chemical composition and legal classification, but enforcement evaluates probable cause, not final chemistry. A lab report may exist. It may be accurate. But it is not determinative at the enforcement stage. How enforcement works. So how does THCA in Virginia enforcement actually begin? Usually through a traffic stop, a complaint, a workplace issue, or a landlord report. Enforcement doesn't start with a lab, it starts with suspicion. Officers are trained to identify marijuana by sight and smell. And Virginia courts have historically accepted those observations as sufficient for investigation. Now, later testing can matter. But it doesn't prevent seizure, charging, or referral to prosecutors. Prosecutors then decide whether to proceed based on available evidence, risk tolerance, and interpretation. And courts? Courts review facts, not labels. They look at whether enforcement actions were reasonable, not whether the retail market intended compliance. Who this affects? This affects consumers first. People who believe possession is automatically lawful because of a purchase source may face seizure, questioning, or worse before legality is resolved. Retailers are affected differently. Even without criminal charges, enforcement action can trigger inspections, zoning scrutiny, or local policy responses. Local governments are impacted as well. They field complaints, respond to enforcement outcomes, and sometimes react by tightening zoning or public nuisance rules. And finally, the medical cannabis framework is affected indirectly. Unclear enforcement around THCA complicates patient understanding and blurs distinctions between regulated medical channels and hemp-adjacent products. Why this matters? This matters for public safety because enforcement discretion shapes real outcomes. It matters for regulatory clarity because inconsistent application undermines trust. And it matters legally, because risk doesn't come from what the law promises, but from how it's applied. Long-term, this uncertainty pressures lawmakers and courts to clarify standards. But until that happens, enforcement fills the gap. Here's a scenario. Earlier I mentioned that THCA isn't evaluated the way most people think. Now let's return to that. Imagine a Virginia resident stopped for a minor traffic issue. Officers notice a substance that appears and smells like marijuana. The individual explains it's THCA, legally purchased, with lab documentation at home. Enforcement proceeds anyway. The substance is seized. Charges are considered. Now contrast that with a different outcome. Same product. Different officer. Different context. No seizure. No escalation. This is where the law becomes clear. The distinction wasn't chemistry, it was enforcement discretion. That's the silent legal question answered. The law doesn't guarantee how THCA will be treated. Enforcement decides first. Resolution comes later, if at all. Here's what to watch next. The natural question now isn't about THCA itself, it's about what would eliminate this uncertainty. Would it take statutory reform? Judicial clarification? Updated enforcement guidance? Here's a question to think about. If enforcement discretion determines legality in practice, what responsibility does the state have to clarify the line? If you have thoughts, or topics you want covered next, share them respectfully in the comments. Like, subscribe, and join the Norfolk City Cannabis Community for deeper, law-focused discussion. Because understanding Virginia cannabis law isn't about assumption, it's about interpretation.